You may proceed.
Your Worship, so the first point is Schedule 5, and secondly, that the circumstances must exist in the interest of justice to be released on bail, and that's the onus upon the applicants. Your Worship, the first part is not that important. It's summarized in a last decision, but it's about the purpose of bail. It's referring to the matter of Kenneth Freeman, and it's simply saying, and that is what is highlighted in that excerpt. It says that bail is not something to dish out punishment with. It's not a measure of sentence or punishment. It's got nothing to do with that. Thereafter, I referred, Your Worship, to the Procureur-Generaal Vrystaat versus Ramaphosa, and specifically the court in that case referred to the matter of State versus Smith and another, which was reported already in 1969, where the court says the general principles governing the grant of bail are that in exercising the statutory decision conferred upon it, the court must be governed by foundational justice. The court will always grant bail where possible and will lean in favor and not against the liberty of the subject, provided that it's clear that the interest of justice will not be prejudiced thereby. See also Rex versus McCarthy. And Your Worship, then the very important decision is referred to by the court in Ramaphosa, referring to State versus Atchison, the well-known Atchison case, which Judge Mohammed said an accused person must rather be released except if he will endanger the justice system or the bail system. I thereafter, and that is the crux on this point is, and that's the only decision that Your Worship in actual fact really has to consider, is the matter of Causa P versus the state. It was actually a White River matter, and it's an unreported judgment, case number A09 of 2017 by our learned JP Judge Lagodi, which said in paragraph 4, now I can indicate to you, Worship, I've attached that decision because it's an unreported decision. It's at the back of the heads of argument. At paragraph 4, the judge said, the purpose of bail is simply to grant him or her freedom and release him from custody, but also to ensure that he or she is present in court for his trial. Now, Your Worship, thereafter, I went to the approach in bail applications, and again, it's not necessary that Your Worship even take cognizance of State versus Stanfield, the Afrikaans, but it's the point that's made there is that the evidence must point one or more of the factors in section 64, and that's basically what Your Worship must do. Now, determining the interest of justice, how do the court do that? The court goes to the 5 subsections, section 60, sub 4, sub A to sub E. Is there a likelihood that the accused, if released on bail, will endanger the public safety or of a person or commit a Schedule 1 offense? Is there a likelihood that he will abscond or attempt to evade his trial? Is there a likelihood that he will or attempt to influence or intimidate witnesses or conceal or destroy evidence? Is there a likelihood that he will jeopardize the functioning of the justice system? Is there a likelihood that his release will disturb the public order, peace, or security? The next page, at page 5, section 60 sub 5 and 60 sub 8a describe some of the factors the court can consider to determine whether there are a likelihood present in each of the above mentioned questions. Now, again, Your Worship, do not have to take even cognizance of State versus Viljoen. It is just referring to the well-known principles in the Dlamini matter. At the bottom of the page, I referred, Your Worship, to State versus Siwela, but that's more in order to point out, even in exceptional circumstances, the court says anything can be exceptional in actual fact. Again, on the next page, the court can look at the matter of Stanfield. The important part it's highlighted, Afrikaans says, al wat hy moet aantoon is dat sy vrylating nie strydig is met die belang van geregtigheid nie. All he has to do is to prove that his release is not in conflict with justice. And then, it's also not really necessary to go to State versus C, it's just confirming the same principles. The one thing that might be highlighted there, dis waarskynlikhede wat die deurslag gee. The court says it's probabilities that's giving the answer, not possibilities. Your Worship, then we can literally move all the way to page 9, or page 8. At the bottom, I refer Your Worship to State versus Lamini, State versus Ladla and Abbas, State versus Hubert, and State versus Kitakat. There the court said the following at paragraph 76. Likewise, I do not agree that because of the wide variety of ordinary circumstances enumerated in subsections 4 to 9, it is virtually impossible to imagine what constitute exceptional circumstances, and that the prospects of their existing are negligible. In requiring that the circumstances proved must be exceptional, the subsection does not say it must be circumstances above and beyond and generally different from those enumerated. And that paragraph is summarizing everything I've said up until now for you, Worship. Then again, there's the matter of State versus Mauk. I referred to that in paragraph 19 on page 9, and that was the exit in paragraph 18. The court literally said the onus must also not be applied too stringently in the circumstances. Otherwise, it makes the getting of bail an illusion. In State versus Kachina 2007, the SCA said at paragraph 25, the court voiced its concern about accused who is detained for long periods before their cases can be finalized and said the following: it makes a mockery of the constitutional rights of detained and accused persons. Your Worship, then we can skip again. Page 10. In the Dlamini case at paragraph 74, section 6011A does not contain an outright ban on bail in relation to certain offences, but leaves the particular circumstances of each case to be considered by the presiding officer. The ability to consider the circumstances of each case affords flexibility that diminishes the overall impact of the provision. Your Worship, and then we can skip again. It's just a confirmation. State versus C again said, dis waarskynlikhede wat die deurslag gee, it is the probabilities that's giving the answer and not possibilities. Then at the bottom of that page, paragraph 24, the likelihood is not merely a possibility. It will be submitted that the Honourable Court, in assessing the factors in a bail application, is therefore tasked to consider the likelihood of the events in future and not the mere possibility of it happening. It's very simple. It's possible for me to go tonight to Geneva. There's nothing preventing me from driving to the airport, getting on the plane and getting to Geneva. But is it probable? It's not probable, because at this point in time, they will most probably not allow me because of the COVID pandemic, or I must also have a visa to visit them and I don't have a visa. So on the one side, something is quite possible, but is it probable? And that is the question that your worship must ask. Is it probable? And that is what the authorities is saying. In that regard, I referred the court to State versus Bennett, which clearly indicated nothing on record shows such a likelihood. On the contrary, there's nothing to suggest that the accused would attempt to evade his trial, influence or intimidate the witnesses, or attempt to conceal or destroy evidence, or in any way undermine or jeopardize the objectives or the proper functioning of the criminal justice system. Now, Your Worship, an important case that I want to refer Your Worship to, and that's one that Your Worship can mark out, is the matter of State versus Hubert. It's at the bottom of page 11. At paragraph 718G, the court said the following: the investigating officer gave evidence. What she had ascertained was that the appellant had previously threatened to kill his wife. He had also threatened to kill his child. On occasion, he threatened suicide. None of these events appear to have been linked by motive. They seem to have been isolated outbursts of anger. The appellant filed an affidavit. The substance of it was that the shot was accidental. There was little or nothing to gainsay this. Psychological evidence was present. It revealed that the appellant had attended a special school. He may be of inhibited intellectual capacity. He's emotionally unstable. And then the court said the basis upon which bail was refused and the stance taken by the state in argument was that unless the appellant was under 24-hour custody, further violence would occur. But important, the court says, counsel for the state could not furnish no answer to what would happen if the appellant was acquitted of murder and released without a prison sentence of long duration. That's the whole point. All these dangers always sketch that this will happen and that will happen, and for that reason the person must be detained, finalizing the trial. But when he's found not guilty, then he's released in any way. Where is he taking the matter at the end of the day? Your Worship, and then I referred your Worship to the matter, and that is on the point of the strength of the state's case. I referred your Worship, to the matter of State versus Kok, where the Supreme Court of Appeal said at paragraph 15, in the context of section 60 sub 11A of the Act, the strength of the state case has been held to be relevant to the existence of exceptional circumstances. State versus Botha en 'n ander at paragraph 21, State versus Viljoen at paragraph 11, there is no doubt that the strength or weakness must be given similar consideration in determining where the interest of justice lie for purpose of section 60(11)(b). When the state has either failed to make a case or has relied on one which is lacking in detail or persuasion, that the court hearing a bail application cannot express even a prima facie view as to its strength or weakness, the accused must receive the benefit of that doubt. The case presented to the court of first instance fell into the second category. The state should have been that should have been an important factor in the magistrate's evaluation of the application. Because of her misdirection, no proper attention was paid to it. And now again, I'm jumping back to the unreported judgment I referred to earlier by Judge Lagodi. At paragraph 1, the court said the following. The main essence of granting bail to an accused person is to give the accused his freedom pending when it's determined that he's actually guilty or not guilty. However, this age of social media trial and repulsiveness shown quite often by our communities to crimes of serious nature, the reverse seems to be the case. At paragraph 8, the court says, for following reasons, I cannot agree with the submission. The fact that there is a strong case against accused person does not mean the end of the road for an accused person in a bail application. The critical issue is whether he or she will stand his trial despite the strength of the state's case and the resultant punishment if found guilty. For this purpose, the accused flight risk was to be considered. Your Worship, and that is the whole point. Judge Lagodi says, even if there is a very strong case, it does not mean that the accused cannot get bail. The test is still, will he stand his trial, yes or no? Paragraph 29 of the Act. In the Dlamini matter, it was stated, the important proviso throughout is that there has to be a likelihood, i.e. a probability that such a risk will materialize. A possibility or suspicion will not suffice. At the same time, a finding there is indeed such a likelihood is no more than a factor to be weighed with all others in deciding what the interests of justice are. The likelihood that the applicant will do any of the things mentioned in paragraph 26.1 to 26.4 supra must be based on facts and not on mere speculation. Your Worship, then I've made a long, and it's just confirming this aspect. It's the matter of State versus Kok again, but Your Worship can skip that, and Your Worship can go to page 16 of the Acts. At paragraph 32, it says, mere accusations by the state relating to the events in section 60 is not enough. And I referred to two matters there, matter of Siwela as well as the one of Jonas. And then again, I referred, Your Worship, to Ramakosi. It's an Afrikaans quotation. I will translate it first in Afrikaans, read it, and then translate it. Daar was wel 'n suggestie van kolonel van Tonder, waarna ek voorheen verwys het dat die appellant redelik gevrees in die Tabong-omgewing van Welkom is en 'n helde figuur is. There was a suggestion by Colonel van Tonder, to which I referred earlier, that the appellant was, people were very much afraid of him in the Tabong vicinity, and he was a hero in the area. Hy het ook te kenne gegee dat die appellant 'n gevaar vir staatsgetuies inhou. He also said that the appellant is endangering the state witnesses. Hierdie was bloot beweringe wat nie gestaaf is of hoegenaamd tydens kruisverhoor verantwoord kon word nie. This is just allegations which could not be corroborated or explained during cross-examination. Your Worship, and then Your Worship can go forward to page 17 I referred your worship to the matter of State versus Muhammad. Now, this case was quoted with agreement by the Supreme Court of Appeal in State versus Botha, and the court said, in my judgment, the requisite likelihood was not established on the evidence. And then the next page, with regards to Muhammad's case, the court said at page 509, paragraph 9, there must be evidence from which such an inference can be drawn. The evidence must not be so general that it does not have a significant bearing on the accused. Moreover, where one of the factors mentioned in section 60 sub 8a has been proved, it does not follow that the likelihood required by section 64e has been established. Your worship, and then you can skip the next paragraph. Paragraph 36 again, I referred your worship to the well-known matter of State versus Atchison again at paragraph 822a. An accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of law is that he is innocent until his guilt has been established in court. The court will therefore grant bail to an accused person unless this is likely to prejudice the ends of justice. The consideration which the court must take into account in deciding this issue is the following, and then the court refers to that 5 questions. Then the court also say, applying them to the circumstances of the present matter, I come to the conclusion that bail should be allowed for the accused subject to stringent conditions designed to minimize the danger that he might abscond or otherwise prejudice the interests of justice. I just want to stand still one very short moment with this decision, and while I'm doing it, your worship can see Dlamini and Atchison is the 2 main decisions of what I've said now, because they contain all the principles. The facts of the matter of State versus Atchison, it's a very serious case, your worship. The allegation was that Mr. Atchison was a sniper who attacked Advocate Anton Lebowski, who was a freedom fighter for the freedom of Namibia, and he killed him. A planned murder as one can't even think of. Now, Judge Atchison said in that judgment, Atchison single-handedly almost overturned the whole democratic process in Namibia, and that it was a very serious incident. An incident that was so serious that the bail application was considered in the High Court. It was not even considered in a lower court. But Judge Muhammad says, despite all of these serious issues, and the judge said in the judgment, me as a person, I don't want to give him bail because of what he did. But I'm not sitting here as in my personal capacity. I'm a judge that sworn to uphold the law. And if I uphold the principles, then there's nothing. Even though Atchison is an Irish citizen with no extradition treaty with Ireland, the judge says, despite that, there's no indications that he will abscond. And the court granted him bail. The sad part of it, despite the big issue that was made of that case, your worship, in the bail application, months down the line, the matter was withdrawn and did not went to trial. Your worship, then I referred your worship to State versus Branco, where the court said, finally, a court should always consider suitable conditions as an alternative to the denial of bail. Your worship, thereafter, I referred your worship, and that is with the topic, parts of community vis-a-vis the community and public order. That was now with regards in this case, and that's what I will submit to your worship, that there's a grouping in the same party that's not happy about the lists, and that caused an incident to happen. Now, on the next page, paragraph 59, the court said, the Constitutional Court in the Dlamini matter, at paragraph 55, it would be disturbing that an individual's legitimate interest should so invasively be subjected to societal interest. It is indeed even more disturbing where the 2 provisions do not postulate that the likelihood of public disorder should in any way be laid at the door of the accused. Your worship, the further decisions in that regard, your worship can ignore. It's not that important. It's being contained in what was said in this matter of State versus Dlamini. The other 2 is just confirmation of that. Then I go to page 21 of the heads of argument. That's the facts of this application. Paragraph 42. The first very awkward thing that I've experienced in this bail application is in paragraph 42. The state never revealed at the start of this bail application whether they oppose bail or not. And if they do, on what basis? The state merely indicated that this is a Schedule 5 bail application. So the accused had literally to do this bail application in front of your worship in the dark, because they did not know up until the investigating officer came and testified whether the bail is opposed, or if it's opposed, on what grounds it was opposed. Your worship, it will be submitted that this is a Schedule 5 bail application, and the court already made a finding in this specific case with regards to the other bail application that this is a Schedule 5 bail application. Page 22, the applicants provided the necessary evidence through their statements and witness statements that it's in the interest of justice that they be released on bail. Also, that the state's case against them is non-existent. 4 witnesses deposed of affidavits that applicant 1, accused 3, and accused 5 were inside the restaurant during the shooting. Both applicants said the same, and is further corroborated by Brigadier Nkobeni of the police, who confirmed that it was in actual fact applicant 1, accused 3, who contacted him and informed him of a shooting in progress outside the restaurant while he was in the cover of the building. Your worship, in front of you it's evidence, 4 witnesses under oath, and of the 2 applicants in that regard, as well as Brigadier Nkobeni, 7 statements. That's all running one thin line against an alleged 2 statements that the state have implicating accused 3 and 5. The state does not dispute the following: that the alleged incident occurred on the 22nd of August 2021. The police at that stage had nothing preventing them from arresting any of the accused if they had credible evidence and any real fears that these accused will interfere with witnesses or they will abscond. The police obtained 3 alleged witness statements. We heard it's only 2 of them that's applicable. That's what the investigating officer says. But he confirmed, after quite a lot of effort convincing him to answer the question, he confirmed that those 3 statements were taken 26 August 2021, 2 September 2021, and 9 September 2021. And it's in those statements the allegations are being leveled against the accused. Now, I, with due respect, ask the following questions. What prevented these witnesses to make the statements on the scene or on the day thereafter? Isn't this reasonably expected from a person who's honest about his allegations and what he saw? If one is involved in such a serious incident, why will you wait so long before you go and depose of an affidavit? I want to submit to you, worship, the only reasonable inference out of that is that was only done after this group had their discussions about this matter to decide who to implicate and who not. Your worship, there are 3 witnesses. That 3 witnesses, according to their versions, were parties to the nomination and candidate lists for the election. That is what the warrant officer testified. It is submitted that this already clouded their evidence with a motive to make false allegations, because they are not happy that they are not contained in that election list. Despite having the 3 statements all by the 9th of September 2021, the police waited until the 17th of September before they arrested the first 2 accused in this case. and thereafter decided on 28, it should be 27 September 2021, to charge the other suspects. It will be submitted that the hesitation in this regard by the police indicate the uncertainty of belief in the versions of the alleged witnesses' allegations. It's obvious that the police had an hesitation. Why did they have a hesitation? Because they don't believe those witnesses as a result of the fact that they realizes this is infighting in a political party. The police received full cooperation from the three applicants, despite the fact that the applicants from the beginning vehemently denied the allegations. The applicants went voluntarily to the police station upon the request to report, and a week before they did so, provided the state with a full version of events with their witnesses' statements. This while the state didn't even divulge at the start of this bail application whether they opposed bail or not and on what grounds. I want to stand still here, Your Worship. A week before their arrest, these witnesses' statements is provided to the state in the form of the state prosecutors, who provided it to the police. What do? They don't go and investigate anything that is said in that statement. The investigating officer admitted he do what is against the law. He says it was against the law. He contacts the one witness and try to get him to change his version. A defense witness, because he did not in the beginning did his work and obtain the statements from the person from whom he was supposed to obtain the statements. And then he says the defense was not entitled to obtain that statement. Why? That the truth can't come out in court. That's the only deduction one can make from that. That's why he does not want that to be done. With all respect, he said to Your Worship, he knows that the person of the status of the MEC is going nowhere without a policeman guarding him. Is that not the first place you go to obtain a statement from that policeman if allegations are being leveled against the MEC? But they did not do that. Why? He's not interested in the truth. He's interested in the case of his complainants, showing clearly the fact that he's not objective at all. And Your Worship will see further through this argument how serious this is stretching and how far this is going. The far-reaching consequences of these actions by both the state prosecutors as well as the police in the circumstances. I then indicated to Your Worship that not only the incident but the allegations made by the witnesses are fueled by opposing parties in the same political organization. The state did not dispute any of the personal circumstances of the applicants. They in actual fact confirm same. Your Worship, it will be submitted that the applicants have shown through the evidence adduced that they have fixed abode and strong ties to the area in the jurisdiction of this court. They always previously attended to their obligations and bail conditions incumbent upon them, that is in relation to accused 3 and 5, as 4 has never been arrested. They never previously interfered with any of the witnesses nor the state's case. They always returned to court when ordered to do so, accused 3 and 5 again, as 4 was never arrested before. All 3 applicants have fixed income and definite financial obligations to attend to with persons dependent on them. They will not commit scheduled offences while on bail. They will adhere to all bail conditions. Now, Your Worship, paragraph 47. From the evidence of the investigating officer, the following is apparent. With regards to accused 3, accused 4, and accused 5, he opposes the bail mainly because they are in danger if released on bail. That was, in actual fact, in the beginning, the only reason. The allegation is not substantiated by any real indications and is contradicted by 2 things. The fact that nothing happened from the time of the incident until the time of arrest some 7 weeks later. 2, that the IO have the opposing group who is his witnesses at an undisclosed location in Gauteng. This is therefore a mere empty accusation and not a likelihood. Next one. The fact that accused 4 and 5 doesn't have fixed property and will therefore abscond. Again, an empty accusation, as he visited and confirmed both their addresses. This was also in contradiction to his own evidence, where he earlier testified, and I quote, "Prosecutor, if they are released on bail, will you easily find them? Yes, it will be easy as they are well known." So he's contradicting himself in that regard. Your Worship, and this is showing the honesty and the objectivity of this investigation witness. He makes an issue with 2 of the accused, 4 and 5, regarding their employment situation. I just want to stop there. Your Worship, if they were unemployed, is that already a cause to refuse someone bail? Must you be employed to get bail? Never. That's not applicable. It's one of the circumstances which is just making more certainty maybe that the person will return. But the person's bail cannot be refused because he's unemployed. But he says, the one is unemployed and the other one said he's driving trucks. He was blatantly caught lying, as he's contradicted by his warning statements, Exhibit E and Exhibit F. At one stage, he indicated that the applicants might, and that's not a likelihood, influence the witnesses, but then changed his evidence and says that they, the witnesses, have been hidden away in Gauteng, and only he knows about their whereabouts. Even considering the change in evidence, the argument initially was an empty accusation, as again, the 7-week time has lapsed, and there were never even an attempt in this regards. Your Worship, I want to get now to most probably the most serious part of this case. And I'm saying it with the greatest of respect. One don't easily say these things, what I'm going to say now. One must have very good reasons to say this. It is submitted that the following aspects from the investigating officer's evidence are very serious and almost shocking. His witness indicates or implicate applicant number 3, accused number 3, only that he fired at the complainant in the attempted murder charge. Your Worship will remember his evidence in that regard. That's the only allegation. How, even if that may have been the truth, is he arresting accused 3, and that the state prosecutors prosecutes this accused for 2 murder charges, which there's no allegations against him? It's shocking. This also in the light that there are no allegations because of an obvious lack of evidence in that regard, that this happened with a common purpose. And while this, according to the facts, are unplanned murders that happened on the spur of the moment. The same is applicable to accused 5, and it's even more shocking with regards to accused number 5. Your Worship will remember, he did not, at no stage, implicated accused number 5. Your Worship asked him, I left it because it's not necessary to ask him about accused number 5 if you give no evidence about him. Your Worship then went and asked him, but how do you link number 5? Now your Worship will see how far he goes to lie. He says to your Worship, the same it's applicable to accused 5. He says to your Worship, accused 5 had a brick in his hand with which he was hitting a vehicle. Now your Worship, if that is the truth, what is the charge against accused number 5?
malicious damage to property. That's not what he's charged for at all. There's no such a charge in this case against him. He's being charged for 2 murders and for attempted murder without any evidence at all. But now it's getting even worse. This aspect, with the greatest of respect, reveals the absolute dishonesty of the IO, Mr. Bila. The prosecutor asked him, your worship will remember, who damaged the vehicle with the stones? And he said, he verified that on the so-called video footage. And he said to your worship, it was accused number 1, accused number 4, and accused number 2. No accused number 5. So the moment your worship confronted him with what evidence is he linking accused number 5, he realized there's no evidence on any charge against accused number 5, and now we must explain why he's in court. So what is he doing? He says now to your worship, no, he was the one that was damaging the vehicle. But he contradicted himself because he already committed on the other accused during the evidence in chief. Now your worship. Yes, your worship.
Can I just leave it? Okay, thank you, Mr. Jordan. May I proceed?
Your worship, what he said, and this is why I'm saying that this matter, it's absolutely shocking and serious. With this charging of accused number 3 and accused number 5 on 2 murders that they had nothing to do with on the state's allegations, and number 5 not on any one of those charges, what does the state and the police do? They create the perception to the families of that people who were killed in this incident, telling them that it's these people that murdered them, while it's obvious from their statements that that is not the truth. Now, your worship, that's shocking. You get people to be cross, for instance, against accused number 3 and accused number 5. Because why will the police arrest people if they did not do it? Why will the state put it on the roll if they did not do it? But the evidence in court under oath is accused number 3, according to those allegations, had nothing to do with any of the 2 deceased, and accused number 5 had nothing to do with the 2 deceased and the complainant in the attempted murder. Is that fair? Is that justice in a constitutional country like South Africa? I say definitely not. And that's why I say this is a shocking state of affairs, what is going on in this matter. The investigating officer's evidence goes further to say, with regards to Exhibit 820 to 825, that he, from the 6 statements, only dispute the statement of Sergeant Mbuyane, and he only do so because he's unhappy that the co-police officer provides a statement to the defense and not to him. That's the only reason he objects against that. And then secondly, he objects against the statement of Sibusiso Mdludli, as he must still be arrested. With the rest, he does not have a problem. And I asked him that. He said, no, he's not having a problem with that. The ones that he's having a problem with is that too. He doesn't dispute the rest of the statements. This includes the statements of Mrs. Mkonza, Ms. Koza, and Mr. M. Zulu, who all declare that accused number 3 and accused number 5 were inside the restaurant when the shooting happened. Your Worship, I want to submit the court should further take into account that no firearms were recovered from accused number 3 or accused number 5. They don't even possess licensed firearms. There are no linking evidence between accused number 4's licensed firearm and any object or body at this stage. With due respect, should they had to obtain this evidence first before an arrest, considering the hesitation of the so-called witnesses to make statements and the discrepancies between their versions and that of the independent witnesses of whom the police and the state had the sworn affidavits of. The time it will still take to finalize the investigation. The IO says only 2 months. What is surprising is that 2 months has lapsed since the incident, and the IO doesn't even have the post-mortems yet. It is humbly submitted, taking the allegations of the witnesses of the state in consideration, that the arrest and the charging of the accused currently is malicious, as there are independent witnesses who deposed of affidavits and whose evidence is not even disputed by the investigating officer. Then, those statements contradicting the version of the 2 state witnesses, 100% state witnesses who have a huge motive to falsely implicate. The state was provided with these statements before the arrest, and they decided not to consider this, but blindly went ahead, arrested the accused, and charged them in court. The state did not even attempt to investigate the contradicting versions in order to ensure a correct and a proper decision in the circumstances. Your Worship, just before I end off, this morning while I was waiting here, I thought about one decision that I always or recently carries with me. Maybe it's also an unreported judgment. I've got a copy here that I can maybe hand to the court. It's the matter of Mabunda versus the state, also by one of the local judges. It was a Nelspruit Magistrates Court case that went on a bail appeal. I will refer Your Worship specifically to page 11, paragraph 37 of this decision. The appellant alleges that he has never threatened anyone. Page 11, Your Worship, it's at the bottom, page 11. Paragraph 37. The appellant alleges that he has never threatened anyone and denies having a disposition to violence, whereas the state's evidence establishes that the stepson confirmed 2 previous incidents of assault on the deceased as well as a threat to kill the stepson. State versus Dylan Tenaver, Kubusi J stated as follows at paragraph 14. The court cannot find that the refusal of bail is in the interest of justice merely because there is a risk or possibility that one or more of the consequences mentioned in section 60 sub 4 will result. The court must not grope in the dark and speculate. A finding on the probabilities must be made, unless it can be found that one or more of the consequences will probably occur. The detention of the accused is not in the interest of justice, and the accused should be released. Paragraph 39. A previous threat made by the appellant towards his stepson does not establish a likelihood that the appellant will harm his stepson. In any event, should anything happen to the appellant's stepson, the neighbor, or for that matter anyone else related to this incident, the appellant will be the prime suspect. This also applies to the state's witnesses' fear of the appellant, as it's common cause that the appellant shot the deceased in a domestic dispute, and that the state witness, the neighbor, can in essence only testify in respect of this common cause fact. A finding that it is likely that the appellant will harm or interfere with this witness or any other state witness is not justified. The state only opposes bail on the basis of the strength of the state's case, the strength of which was not seriously or adequately disputed by the appellant. Although prudent that the strength of the state case and the probability of conviction ought to be considered, it ought not to displace the primary purpose of bail and whether the interest of justice permits the appellant's release on bail. All of the above considered in conjunction with the evidence in quota quo in its totality, duly allowing for the fact that the evidence by the appellant was on affidavit, I am satisfied that it's in the interest of justice, as required in terms of section 60 sub 11b, that the appellant be released on bail whilst imposing bail conditions to employ the appropriate checks and balances.
Now, Your Worship, in conclusion, I said the following in the heads. It's humbly submitted that there are no likelihood that the applicants will endanger any person or commit any further Schedule 1 offences, that they will abscond, interfere with witnesses or the state's case, will prejudice the functioning of the justice and bail system. It's submitted that they will adhere to all bail conditions, or the appellants will not endanger. There's no likelihood that they will endanger the public order or safety. It is furthermore humbly submitted that the applicants satisfied the onus resting on them, and they proved that they had met the higher benchmark of exceptional circumstances, which are in the interest of justice, justifying them to be released on bail, even though the requirement is only circumstances and not exceptional circumstances, and that it's in the interest of justice that they be released on bail. Wherefore, the Honourable Court is humbly requested to allow them on bail, coupled with the necessary conditions. I just lastly want to submit to Your Worship. I can understand the unhappiness and frustration of people. And Your Worship must consider the severe consequences. We all know the severe consequences already, for instance, that's happened now with accused number 3. Why? Because he's accused that he murdered people, and there's not even evidence against him. Your Worship, I humbly beg the court to find that it's in the interest of justice that all 3 the applicants be released on bail. That is my submissions to Your Worship. If there's anything specific Your Worship wants me to address Your Worship on, I'm more than willing to do so, as the court pleases. Your Worship, that's all, except if there's something else Your Worship wants to hear me on, then I will address Your Worship, as the court pleases.
Your Worship, my submissions are as follows. It is not a dispute, but this is an application, formal bail application in terms of Schedule 5, and the burden of proof is on the applicants to prove to this court that to prove on a balance of probabilities, Your Worship, and to adduce evidence that will satisfy the court that it is in the interest of justice that they be released on bail. Your Worship, with regards to the testimony of the investigating officer, he indicated, Your Worship, or narrated to this court as to the events that unfolded on the date of the alleged incident. I'd like to stress more particularly to the brutality, the violence that ultimately led to the results of 2 people dying, as well as 1 person being injured, Your Worship. I'd like to further stress the fact that the investigating officer indicated that there are video footages and there are eyewitnesses, Your Worship. Furthermore, Your Worship, I'd like to submit that the state case against the accused is strong, and if found guilty, Your Worship, they face penalty with regards to the Minimum Sentences Act. Your Worship, with that being said, I'd like to indicate to this court, Your Worship, that should this honorable court, Your Worship, see it or deem it fit that the accused be released on bail, I'd like to submit that strict conditions be put in place accompanying the bail release, Your Worship. Most in particularly the reporting to the police station at specified dates and times. The passports of all accused, Your Worship, to be handed over to the investigating officer pending finalization of this matter. Thirdly, Your Worship, I'd like to submit that the bail amount should be set higher in order to ascertain the attendance of the accused until finalization of this matter, and for the accused to be informed not to interfere with the witnesses or jeopardize public peace and the proper functioning, Your Worship, of the criminal justice system, as well as not to commit Schedule 1 offences, Your Worship. Your Worship, I will leave it in the capable hands of the court to take a just decision, Your Worship, as the court pleases.
Your Worship, the only thing that I want to respond to, but I will leave it for the appropriate time. I just want to indicate to you, Worship, it seems that the state almost is conceding to bail, but be that as it may, if that is considered, when Your Worship must consider an amount, I want to address Your Worship on an amount of bail and possible conditions. That's the point. As the court pleases, Your Worship, where are you?
As the court pleases. Yeah.
through, and so that when I give judgment, I must give a sound and proper judgment. Should there be anything, or maybe if you think of taking me to N4, so that I can, so that all, in fact, all the reasons are furnished in my judgment.
Is it possible that your worship can make a decision and then later give the reasons for that decision?
No. Unfortunately, I want to give a full judgment so that each and every person who is before court, he can be understand my reasons. Remember, this case is gain a public interest, and each and every person wants to know the outcome of my judgment.
Bishop, if that is the case, is there no chance that the court can do it earlier than Tuesday?
Earlier than
Especially-
Tuesday is Monday.
Especially in the light of the fact that, as I've indicated to you, Bishop, that the state actually conceded.
The decision of the state is not decisive.
Yes, no, that is so, but it is a factor that's playing a big role in what your Bishop will decide.
And I have to consider whether it will be in the interest of justice.
Yes, Bishop.
Yes, taking into account all the evidence presented before me.
Yes. Yeah, as I say, I will just request that the court maybe consider to do it as soon as possible. I think that's also in the interest of justice that it being done as soon as possible.
Police. Tuesday.
Yes, Bishop. I'm even willing to come in Saturday or Sunday. I don't have a
Well,
problem. It's, Your Worship, it's exceptional circumstances that we have here, and that's why I'm willing even to go to that end. So I'll ask Your Worship, request Your Worship to do it as soon as possible. I think it's important.
yeah, no, I do understand, Mr. Jordan,
Yes, Your Worship.
and I'll also take into account that your clients are in custody.
Yes, Your Worship.
Yeah, but as I've just indicated to you that I have to give a proper and sound judgment.
As the court pleases, as long as Your Worship can do it maybe as soon as Your Worship can.
Yes.
As the court pleases.
No, it won't be later than Wednesday.
Pardon, Your Worship?
It will not be later than Wednesday. You know, another thing that contributed to this matter is that bomb threat. Because maybe if on when was it? Was it Wednesday or was it Tuesday?
Wednesday, Your Worship.
Yeah, Wednesday. If on that day everything went well, maybe you'd have done with your address everything there. Today it will be for judgment, and maybe yesterday it would have gave me an ample time to prepare my judgment. But because of the delay that we have on Wednesday,
Bishop, no, I understand that, but I'm just asking again that Your Worship consider if Your Worship must postpone it to the earliest that I will make myself available again for Monday as well. I know that Your Worship already have quite a lot of insight in this matter with the other matter as well. So I will ask that Your Worship consider that we can get it done at the earliest opportunity and if possible at all. As the court pleases.
yeah, but the nearest day is Tuesday.
As the court pleases, Your Worship. I think the request to Your Worship, but if that is Your Worship's decision, is Your Worship's decision.
Worship, the date on Tuesday is the 19th of October.
Okay, gentlemen, stand up. Okay, your matter is postponed until the 19th day of October 2021 for judgment. You remain in custody, but you are going to be in this court 9 o'clock. You'll be here at 9. Is it fine? Because first thing in the morning, Tuesday, I'll be starting with this, with my judgment. Then I will deliver judgment on the 19th. As soon as we start in court, then I will proceed with it.
I'll ask that the worship endorse the lines again for the next session.
Do you all understand? 19 October 2021, that is for judgment, and you remain in custody, but you are on for 9 o'clock early in the morning. Good book. Court book.
With the contacts assisting with the rest of the community court.
Thank you.
Any excuse to you?
No.
You wish to adjourn?
Yes. Thank you, everyone. Agents.
All right.
Wait.